Good morning, my lord. I'm sorry I don't know the protocol so much about to address you and judges and a magistrate. We are really, really grateful that you are here today. We call you and you came. The truth is that we are the ICT. Leave the microphone, work on this to make sure this thing works.
So that's one of the basic things. So the law was legally signed to law June 26, 2025, with effective date January 1, 2026. What are the significant objectives of the law? The reason why we are just talking about some of those bases of this particular area is that because we have a lot of misinformation in respect to this law. The corporate business is exempted. Any business that is taking 100 million, 100 million, that 100 million turnover is 100 million of they are exempted for company income tax. Or when the asset base is 250 million, they are also exempted for company income tax. So we have a lot of benefits. Like for instance, so a lot of VAT. We have the VAT relief from exemptions and very VAT. All basic food items, they are also exempted from VAT, among other things. So we have that. Other areas that for just no, it's about stimulating development. The capital gain of that itself will be charged on the capital market. No, capital gain that exemption applied to all investors about 99% of conditional. Then the even minimum wage earner, we say not at all. In the new tax law, anyone only the national minimum wage and below, they are all exempted from payment of personal income tax. Unless one person has additional business that they are doing. But if it's today, 7,000 they approve national minimum wage and they are exempted from personal income tax, which normally called pay. Nigerian diaspora with tax now. Unless Nigerian diaspora have economic presence in Nigeria, which they don't declare in their own country as part of their business. So that's where it is being completed. The intention of that benefit be taxed up. Pensioners are also exempted from personal income tax unless the pensioner is also engaged in some other private commercial activities that earn income. Then what are the new legal framework? We have 4 major taxes that are being signed to law. The Nigerian Tax Act. Nigerian Tax Act now brings in all before now we have different tax laws. They will make it difficult for the lordship to work with. Like now, somebody will have a particular state revenue tax authority bringing a case in. They will bring a case on paying tax, the particular taxpayer, on family history. They will bring another case that has a particular taxpayer on personal income tax. If you make reference to it, you have to look for family tax. Now you look for personal income tax. You look for law that has to do with data. So they are all different laws. But now this Nigerian tax act brings in all the taxes, every taxes that we have in Nigeria is under this Nigerian tax act. So you don't need to make reference to different laws anymore. They are all in the same one single law, which Nigerian tax act. Then the second one we have Nigerian Tax Administration Act. The Nigerian Tax Administration Act now brings in all the relevant tax authority and professionals, this the state revenue service, the activities, the federal revenue service, their activities, the professional, this governs the revenue administration. This how it works on. Why the Nigerian Revenue Service Establishment Act now, which gives all the places federal revenue service. There are no more federal revenue service, the Nigerian revenue service. And what is the major reason why the name is being changed? What the major essence is that the revenue collected by FRS before now is being shared by the 3 tiers of government, the federal, state, and the local government. So when we now say federal revenue service and they are collecting revenue shared by 3 tiers of government, so they look at it is not in the best interest of the country and because of the avoid litigation. Because the issue of past, that particular litigation for respect to past, legal state, and River State, the 2 people of the very reaction of the last president, Buhari, so that's what we're doing. And the Nigerian Revenue Service also now, most of the MD, the Customer Service, the NASA, other entities that they go and they focus majorly on revenue, their core activities. They are not focusing on things. So those activities are revenue based now treated to the direct side. So that those entities are focused majorly on their core services and to enhance each of the business in Nigeria. When we have important business investors in Nigeria, they have to move it from one engine to another revenue matter, but not just one-stop shop and we resolve this particular revenue. Then we have the Joint Revenue Board establishment. The Joint Revenue Board establishment, they are over JTB, Joint Task Force. They are one that regulate the activities of the revenue board. So the organization, their disputes, they are one in charge of it. Okay, under this Joint Revenue Establishment Board, then we have 2 other laws that are there, which is the Tax Appeal Tribunal. The Tax Appeal Tribunal under this Joint Revenue Board. The Tax Appeal Tribunal are just government like the revenue courts. But presently they are being they have them in regions. Like we have in Ibadan, so they have that in Lagos and some other 6 or 8 Nigeria presently. The Tax Appeal Tribunal. There was also another within just this Joint Revenue Board called the Tax Ombuds. Tax Ombuds is what their own major focus. They are just like arbitrator. They cannot give a taxpayer in look at their bill, they cheated, and they don't have any point to go to the tax board and tell them they are lazy all the tax authority resolve it, but they cannot make any decision. So if at the end of the day it is not being resolved, the taxpayer or the tax authority can appeal to the revenue court, the high court, or the tax appeal tribunal. Then what are the key implications of this LT? There are some of the key implications. These are some of the areas whereby your lordship will have a lot of issues, like in terms of registration. It is mandatory in the Nigerian tax section 4 section 4 and up to section 8 of the Nigerian Tax Administration Act talk about mandatory registration. That every individual or taxable person, either company or individual, is mandated to register for tax ID. So the lordship, we have not done that. It is very key because the Nigeria is migrating to a particular area. Even some of the services like perhaps authority use tax ID. Irrespective of our payment, the tax ID just has not like an account of our tax payment. Any payment that are made with respect to tax, including any part of the state of the all payments will be under the tax side. When you just speak in tax side, your payments will be just like formerly they call it tax identification vaccine, but now it's called tax side. What I do of the tax side stated on the returns, those used for purpose of tax compliance, condition for entering the contract with any federal, state, or LG, local government, or bank, insurance, or looking at other financial services. So the time question for this, open a account must have your tax ID. And we know in the law for failure to have any organization, any local government, or federal, to give contract to anybody without tax ID, the penalty for that, and up to 5 million naira or failure to for granting contract to someone without tax ID. Then the key, we are just going to this by all this. We don't have much implication with law, but for us to just have some big information about the tax law. What are the expected impact on this? We have on businesses, on household, on block. But majorly, I will focus on the household business because of our time. Elimination of minimum tax on capital. Before now, the tax that is operating before correct that even if you make loss, any business making loss in Nigeria, can pay what they call minimum tax. That is system that we pay loss, we pay minimum tax. So with that now, so that has been eliminated. If you pay loss, you have nothing. People your loss are paid. You can also becoming pay profit. Those are the you can also recover as loss free. So that was the system to encourage, to boost business investors, and they can make more. So starting of that, they go start with this start of education. Then we're coming for household, which are all transport subsidy, on food imports. That's why we see some drastic reduction in food importation, because of this food. You see a lot of food import food prices is basically the price are dropping because of some of this labor, but because of this issue, that was is bringing them up with it. Then for lower tax, but we go even earner like the someone living more with their exempted. And if you are not, if your salary in the year is not up to in the year is not up to 20 million, you are expected to have a little drop in your personal income tax, unless if before now they are not paying appropriately or adequately. The opportunity for business, small business within startup, they are all exempted. Then you also have for other areas, other education again before filing of annual return. This is what is all correctly. The major based on the law from January 1 to January 31st for verify the annual returns for employees. Like for instance, the beneficiary is expected to file annual returns for all the just employees, the magistrate, and their staff. the annual return that's salary there, whereas individual, you are also expected to file your own. Thank you. Whereas individual, you are also expected to file your annual return. So based on the law, income tax return for company is section 11 under the Nigerian Revenue Service handle that. Income tax return for individual section 13, which is the state revenue service are responsible for that. Paying employer salary return section 14, state revenue service also for that. What the major significant change now in this income tax return now is that in this new law, normally if the employer apply return for those it is not expected for you as individual to file annual return anymore. But the new law, after the law has filed, it is mandatory for all taxable persons to also file their individual annual return. And what is individual annual returns now is that, like for instance, now judiciary has filed on behalf of the now is that you are going to file on your own. If that is your source of income is mainly employment income, you file just say employment income. But anyone that is having some other businesses or side also go to the trade, business, and profession. You also file your income here. So based on that, that's when the tax will be completed. In this particular situation, in the Western world and perhaps for it's a very criminal offense, and there is offensive for this particular one. Like for instance, now the offense are penalty, we don't have time to go through everything because the best penalty to this law is from section 100 to 127 of the Nigerian Tax Administration Act to be able to cover the cost of the time. So for this individual now, for you to find that in the same time when you start and we said the deadline will start for the so it has been extended to tomorrow. From tomorrow it will expire. So anything for me now for failure to file based on the law is 100,000 naira first month. Then every subsequent month below 50,000 naira each. That is based on the law, the Nigerian Tax Administration. So now section 14 now said, notwithstanding the provision of subsection 1, the subsection 1 now, an employee shall file an annual return of his income for all sources. So what the subsection 1 is that, subsection 1 of 14 is that the employer has file on their behalf. So it's not saying that notwithstanding the provision of subsection 1 of this page, section 1 of 14 now, an employee shall file an annual return of income for all sources, including employment income, in accordance with section 13 of 20. And what is the section 13 of 20 is individual annual filing. So this talk about simplified income tax return, section 15. The term of virtual annual service provider is just speak to the Nigerian tax. The Nigerian tax those that are into virtual assets like crypto or Bitcoin, because of that, some of these is some of the young, but see some of them make billions, make hundreds of billions. It's not into their own, because it is not managed this way. Some of them are into legal businesses like all this crypto, but it's not managed whether it's some of them by people. So it is not in the law. Law, tax authority cannot tax virtual assets. And they are also expected to file returns with respect to that. Then the return on deduction at source, like the returning tax, the file returns with respect to information to be delivered by bankers and others. Section 29. It's expected that bankers must file returns in respect to all new customers that is opening accounts in the bank. Must file returns before filing return. So or a returns on all customers that will individual that is accumulating transactions to the filing return. You must file bank must file to all internal service. Then if it's for company, if the transaction is of 100 million and above, it's also expected to file. These are some of the basic way where the tax authority gets relevant information about the taxpayer. For instance, someone that finds, someone that claims that yes, your five camera costs say your total income for the year is 2 million naira. Why the bank is finding their own annual report, their quarterly report. That same person that is claiming 2 million naira, when they check, the bank is reporting about 100 million, 200 million, the respect to that person. So the tax authority into that. So they understand that to prove that this particular one is not or that's another thing. Then disclosure of tax value. So accreditation of tax agents. So because of our time. Then I just want us to use I just ask some of this basic information about how the tax is computed. We don't need much of that, but just also have some basic information. So here is that out of the bill they are receiving, the tax are being computed that. For instance, the entire gross income we see in our employment is this what we have here, the entire income, salary, wages, allowance, pension of bonus. You can see one. Okay, I will have them now. So we have what they call allowable deduction. Allowable deduction is that anyone that into NHS contribution, national housing or contribution, the amount you pay tax or contribution is exempted. It will be removed from the entire gross income. National housing insurance scheme contribution will also be removed. Pension contribution in terms of contributory pension scheme, which is 8% contributed, will also be removed. If you have interest on loan on our buy house, you will remove. Life insurance policy, if you have your life insurance policy, pay don't be expected, give it to the accountant that is computing it, they will remove it from your gross income. Then 20% of annual rent stage, it's maximum capital. 500,000 also the book. So when they remove all this, now the balance here is what is starting. Like for instance, they are having 10 million, if all the productions here is around 2 million. It's not the entire 10 million tax, 8 million now the tax. So this is now the portion as being pressed. So the first 800,000 of our taxable income is taxed at 7%. So even the Dangote of this world, as the richest man in Africa, is 400,000 taxable income is taxed at 0%, and it's also set in this particular way. The computation. It's not just a flat rate. Then it does a template of the new tax law. They just increase the annual cost, like for instance, the annual rate someone is paying 1.2 up to 60 million. Then let's say those deductions, and let's say you look at it for at 5%, look at the deductions. In the old tax law, someone that is receiving 840,000 naira on yearly basis annual, the tax is 7 naira. But for 30,000 naira, but the new tax law is paying just the same thing is applicable. Someone that is receiving 3 million annual, the new old tax law is paying as much as 200,000, while the new tax law is paying 85,000. We have a marginal difference of 14,000. So before you see the increase from when you get to around 20 million, so here we now have someone that is giving 18 million annual. The old tax law we have 2.8 billion, 2.85 form. The new tax law 2.8 we have about 24,400 savings. So when you now look at it, so when you get to 20 million and above, that's when 20 million above, you see the increase. That's what the effect. So the new tax law is not to put much money on low income earner or that they are not targeted. So now I'll just talk briefly of this. The tax very clearly have to do personal income tax and they have to do specifically with state tax residency. You must be a resident in a particular state when you can make payment to a particular state. Then we also look at it when you're having some economic present in a particular state. There's some of those areas, there's some of things that are not taxed now, which is not in the old tax law. Just for information sake, is that gain from digital and virtual assets. In the old transport, those virtual assets and digital assets, they are not taxable. Honorary award, all those that are not taxable, but now they are into it. The most of money or money instrument they are now put into it now. They want to call benefits in kind. Benefits in kind too. Like for instance, now we have those that use the official task and also the saving and benefits in kind. So the value of it, for cards, 5% of it. So they are seen as income. That visa. There are some of those basic things. Because those litigation, those are some of the relevant things that do call for litigation. When the person that don't be to carry out task of the exercise, and the captures of information that are not taxable, that the tax gathering is not taxable, or the tax authority will not tell that this information they are taxable. That's why you ask the discrepancies. That's in most cases, based on the business experience, that will fall into litigation. Right, because the area that I've seen that is new to that is not taxable. When the tax authority tell you that no, this is taxable. Like when NGO or the bank that is using the official that user, so the for the bank will not tax it, they will not pay benefit in time. It's paying the official quota of the bank. The bank authority or the particular organization will not see that particular that part of benefit in kind. But as authority paid by the law, they will pay some compensation that particular law. So it doesn't pay classes. Those are some of those little disputes that normally lead to litigation. So that's the area I want us to also focus on. Then key changes relevant to court. What are the key changes relevant to court in this particular? So we are now getting back home. So the present law now to define the tax law. We have one law governing individual, company, and transaction. So before now, if you want to see anything that has to do with any litigation that has to do with individual, normally personal contact, make reference to personal contact act. If you have to do with company, you go to and make reference to company contact act. Transaction, they make reference to stamp duty act, value added act. So all this now, we now have the table law called the Nigerian Tax Arbitration Act 2025, and then all this law in one single law. There is another procedure, uniform rule for assessment, collection, and enforcement. You see that as well. So the assessment process that will be carried out in the same time in this service will be the same assessment procedure that is carried out in all state and services in Nigeria. So I don't have any different assessment. Everything is in line with the Nigerian Tax Arbitration Act. Then what are the assessment and compliance? All that is under part 2 of the Nigerian Tax Arbitration Act. We have what we call self-assessment. So these are some of the key areas that sometimes they are also lead to litigation. What is self-assessment? For instance, now, the law under section 36 of NTA or 14 of NTA. In section 13 say that yes, you must file your individual right. 14 talks about employer's annual return. So the employer file annual return on behalf of the staff. Then you know now say that employees also file their own annual return. So if you file your annual return, you are claiming that your income is, for instance, is 1.2 million naira. Well, 1.5 is tax authority. So what the tax is for 1.2 million naira, approximately around 78,000 naira. So 78,000 naira. Then the tax authority now, maybe they are carrying out some profiling in respect to your activity. They now discover that information you are getting from the back end in respect to your activity, either you have other side of the disclosing, or you have information received from the back end that is far more than what you have declared. They will carry out what they will now review, not permit, and they can raise what they call administrative assessment and additional assessment. So that particular situation now, they now say, okay, they are 1.2 million, they are now assessing that. They are not assessing assessment, which is also called best of judgment against 12 million naira. the last particular assessment. That's when you see the dispute. So in dispute resolution, that will come now. Okay, that's they have the right to object, be 30 and file just a particular stage. So now that's where you see some of this issue now. Or that's where I pay that 17,000 bit of self-assessment in line with law. But that's because there's no, but that's the ability for the year is not 17,000 naira or 750,000 naira. So that all those different areas, that's what that lead to litigation. Then we now have what we call active assessment. Active assessment says that now we are fighting on only laws now. So the tax authority has order by law under section 35 of NTA that you can never go active assessment for best of judgment. That yes, information is filed, but information about disclosure is far more than this. That was no active assessment or additional assessment. Even after they release through the active assessment or additional assessment, they now discover along the line that there are some other information not carried out during the initial assessment. They can if law permit that they can issue what for additional assessment. So those additional assessment now, all those little information, all these things sometimes lead to litigation because after they carry out all these two resolution everything. So that's not that lead to litigation. So the law permit to this and one of the standards of notice of assessment, section 14. So the one thing is that the tax authority must serve the notice of assessment The section I will add here, the fraud in relation to staff, either the fraud, a term not exceeding 3 years, or a fine of at least 2 million or both. Then inducement of an authorized officer. We have individual recognized of 500,000, public recognized or a term not exceeding 3 years or both, in addition to paying the tax due. Use of weapon, if armed. So if you use weapon to attack the tax officer, a term not exceeding 5 years. If the tax officer is injured or any other judicial law enforcement is injured, a term not exceeding 10 years. So we have that in the law under section 116. Then we have impersonation of an authorized officer. That is the fine not exceeding 1 million. Or a term not exceeding 3 years. Aiding and abetting to commit offense, commission of offense, that is the fine. A term to obstruction of officers working. Then false claim of tax refund, that's another major one. We have in the new tax law, if you calculate that yes, you are overpaid, you can apply for tax refund. And it is by law, it's stipulated that the tax authority will inform that particular monetary law support Nigeria Confederation or the Nigeria for the states. So, but if you are paying false return or reform after you have collected that particular money, that is the penalty for that. The false or fictitious claim of VAT refund. So this we have that. So sorry because of my time that I'm watching this file. I will share this particular one so that at our convenient time we can also review. The false declaration, they are one that are declared final exceeding 1 million or a term where 3 years or both, the addition to both payment. On permitting government, be someone or that's used classically in the state. Before the autonomy, we have much of this. We have the tax certificates, we have the receipt. All this one is drastically reduced. So I'm also happy to all those tax application of them to forbid application for all those cases. We have detected some that could be paid. We have some agents that do that. So it is expected that authorities will be confirmed on the relevant tax authority. We should take note of that. The offense of body corporate, that's why I'm sure that if it's a body corporate, before now we have legalities that the company, body corporate is different from. But now, you look at what the director, manager, partner for cities, they have committed your offense unless the person can prove otherwise. So you can prove otherwise that God not have committed that particular offense. Then the general penalty is that agreed penalty is 1 million, fine or exceeding 1 million for 3 years. So that was the last section of this penalty. Then I have to slide more. Then the role of judiciary is that ensuring compliance through enforcement, building public trust in the tax system. That is, must have to only the taxpayer have their rights. The tax authority also have the right and obligation. Not that you just one of the tax authority. So in most cases, the tax authority might be wrong. The wrong process. So why some cases might be the tax payer. So supporting economic development because if some key judgments have been delivered, the casual taxpayer or those that are paying tax, they will learn from this particular. It will also boost the economy of the state. The revenue matter. Revenue matter will be to work on the industrial law. Then conclusion. The reforms aim to require taxation and body tax compliance. All the vital enforcement and fairness, legal credit, balance and application, maintain proper record. Then we have to also take note. We have what we call establish a task board, task board those and administration board, but they cannot take any decision. They cannot give any job, those are administration board. Then I now have a thank you and God bless you. Thank you, so sorry.
spread beyond the time of it. So also we have just about 10 minutes more questions. Any more questions? And this is the plan. I would love for questions to solve questions. For about 10 minutes. What do you think? Is that for various positive representation? My remark was that when necessary, was taking that this has its own to take the view of the within of the states. The other way to mention that any business to go content and other capacity and maybe more we don't start with and somebody in minimum wage. That's but when you get to the assessments, I think so then gross. Because what is be taken for by the right path. Maybe by the right path, taking the president. Used to be the if the tax enforcement, so will be a lot of revenue systems. That's an assessment and in this available. My question is this. Now there is that this window for objection. And the tax authority has 90 days. They wish to also maybe as a wonderful. It's responded. What happens if the tax authority does not respond in the let's take another question. Thank you very much. We wrote out this tax revenue. Good one. We don't But you have to use most of the people are saying here. Despite the fact that plural is much more than the streets. What is your organization doing? Get this into their doorsteps. We all know that this is illegal. And it has generated a lot of misgivings in the streets. Mr. President already identified saying yes. That one is true, this one is not true. That's what is going on in the street pertaining to this as efforts. So what is this organization? What are you going to do to bring down that misinformation and misrepresentation? There is no way that a new law of this nation will not us, will not us. This was good morning. I was very worried. The recording of the because they mentioned of the recording of food. I'm going to tell you quickly, and the main crowd very serious measures of that. And I hope if you have to manipulate it by consider something that but what of food is the matter? can only be legislated upon by the that's not the state authority. So we have domesticated this part of it. You can legislate for it.
Thank you, sir. I would like to start from the last question from Milo. Issue of this body of proof is not major thing that is in our own law. It's empty. Everything has to do with empty. Literally, it's Nigerian Tax Act. Everything that I presented today has to do with Nigerian Tax Administration Act. Not even the state tax. I didn't even refer to the state tax for the laws. It's not the act. Not the act. Some of the things that we discussed within the past years. Yes, that if you are served in liability, the liability that you have been served by tax authority is not apparent. If you have sufficient evidence, you can prove it. That's part of your kind of objection. That yes, you have served this. Even okay, you discover, let's say for instance, that you have filed annual reports that your income for the year for 2025 is 4 million naira. Then we have some background information from the financial institution that your cumulative income for that particular year is more than 100 million naira. It's something that you can object to. No, I received this particular X amount of money from my cousin or my son, and it's in diaspora for a particular project that's maintaining property. When you file your annual return has shown that this is your income for that particular period. So they are just more or less advise the taxpayer that they should have proper documents for all their financial transactions. So these are something that can aid them when matter leads to litigation. So that is just everything is going to be law is just literally as the Nigerian Tax Administration Act. Thank you, sir. Then the second one, we always talk about the ignorance of the law, which is quite we from our own end. We're not even looking at that. We want even the least, our last taxpayer, which we call the customer, to be aware of this law. In the state, immediately the draft of the law, we have the draft of this law. The executive chairman set up a committee led by chairman, former legal advisor, and part of the committee member. We reviewed the law, the draft. And when we discovered some gaps in it, it was sent to the committee for further review. That was one of the gave the state and party as one of the first things to investigate it. So what we are doing presently in the state, like presently, myself at least, and some of our guys here, we have carried out at least with professional bodies. Our members lecture in respect to this law more than 15 professional bodies in state and associations. So we have that several associations meeting with very different IMA, CITN, CIPN, National Management, the Impact, ESU, Abuad, last week, Abuad. I said I'm one of my colleagues, Abuad, I thought international conference also talk about this. Then on almost weekly basis on radio program, headed by the head of publication. Even some cases, we have a sample class being organized that the executive chairman of the publication being a particular radio station. Then all the radio stations in the states we join. So we say if you are saying that I want to listen to the voice of chairman of Progress, we tune to Progress, the same thing. We tune to Miners, the same thing. So it costs us a lot. A character of sensitization so that everybody we have information about that. We are not interested in the penalty or having the borders. What we are interested in voluntary compliance. And how to get voluntary compliance is for us to sensitize everyone. Even in the law, God says that we all inform the final return should be done through electronic camera. So to me, then, part of section 15 of that law, that says that you have what you call simplifying annual filing. It has simplified annual filing for no income the informal sector. We also make a final fight so that they can also feel it out. Then we will now help them to transfer it into the online what they feel that they have signed and we document it. Because we are not after the penalty, it just voluntary compliance that we are after. And we so those of this information they are trying to collect. You have implementation with the NDC, the teachers, the private sector, civil servants. So even the chairman about 2 weeks ago with SO members. So that's where they are different sensitization. Therefore, the objection on issue of assessment, it also said that yes, if I talk about 30 days for objection that was object, while the tax authorities was if the tax payer don't object with 30 days, become final conclusive. Then to protect the tax payer too. In the health year now, we don't have to formal we have got the some tax authority that the tax payer may object. 2 years, tax authority don't respond to that objection. And just for one good deed and of course tax payer. So this is tax law that is now putting that obligation on tax payer or the tax authority. He must respond to 90 days on receiving that objection. Failure to object to respond to that particular objection, they make the grant of that particular tax payer to the bank was sustained, you have to sustain. And if the tax payer has started assessment the tax payer or 5 million, the tax payer saying, no, I'm not to pay 5 million, I'm paying 100,000, and saying that objection 30 days. So if you must respond to it by the tax payer and the consultation meeting, within that particular entity, a grant where you response to sustain that objection to which entity. What if you have to give a that entities that objection or the sustain of that tax payer to sustain the tax payer. So that is the respect to that. Then
Sorry for good on this. I rather than advise that some commissions to give you or extension of that or if you for clarity. For example, somebody is out of that is sick. Unable to do anything until after that. Does the law permit for him to bring an application for extension of the contract?
Thank you, Lord. We have several cases based on practical cases. Even in the law, it is stated that 30 days is final purpose. But in most cases, we don't strictly apply that particular one or human fees in it. We have some cases where the tax payer after 60 days we still write a reminder. Then the tax payer having a family liability as a model to build the case and then the tax payer. Those people who don't like 30 days. After that particular time, the second now, in a situation that the tax payer is in, the tax payer can write a letter, and I haven't received your list, but of your principal assessment, but however, even the right person to attend to is unavailable access from the country that is seeking extension to a particular period, or is not available because of ADS or other things that they can see and can choose a convenient date when it will be available to attend the consultation or to furnish next future problem. So what is clear is allowed.
Sorry. I think we don't have to break down the context. If a serious report okay. So as you can look at possibility of amending that to 5 because you can't waive the of the law. Okay. You can say 30 days. You cannot on your own. What is so it's a serious group now. Most law. Let us have it. Okay.
And I never also speak that it is not directly we are winning this. We are not winning that 30 days. But the point that I'm trying to say is that our own use of human face is that on another situation, if it's no, I understand that that's the essence of yes, and we are that is notice. And we take note of that. Take note of that. Okay. Then we also ask about issue of company business. Talk about company 100 million. Okay. Any other for
Thank you. Some people are focusing yeah, what we need to consider, we are taking so much time on this particular lecture. We also need to apologize to the next lecture that Mr. Sheyalake, Directorate, Lagos State Revenue Service, will be taking the next lecture. We apologize for taking so much time. Now, the technical can take over from Mr. Sheyalake. Are you there, Mr. Sheyalake?
Good morning.
We can hear you. Please go ahead.
Okay, you can hear me?
Yes, we can.
Okay, good morning, everyone. It's my pleasure to be with you, though it's a bit kind of awkward because I can't see what is happening over there, and I can't see anyone. So I'm just looking at my screen. However, I will try to give a good account of what I've been instructed to do, which is to talk about the practical aspect of the activities of the legal directorate, if I can put it that way, of the Lagos State Internal Revenue Service. Our own experience here in Lagos. When we Hello? Okay. Can you hear me? Oh, okay. Okay, right. Good. I don't know if you can also see me. My video is on.
You can see it. Yes, you can see.
Okay, thank you very much. Okay, so yes, so I'm meant to talk about the practical experience in the area of tax adjudication in Lagos State. I know that in Lagos, we have a very, very robust pathways towards recovering tax liabilities. And I must say, it is not only about tax liability, because when you talk about taxation, there are certain fundamentals that are very, very, very important. It's a different thing to chase after tax debts. And it's another thing also to try to engender the spirit of compliance to tax laws. And for me, and for us in Lagos State, that compliance with tax duties and obligations is what is most important, because that forms the very foundation of tax administration. So in Lagos State, we take very seriously any non-compliance with tax obligations, especially arising from filing of returns. when a taxpayer fails to file their returns, annual returns, and I must, maybe for the sake of letting us understand all the perspectives, there are different kinds of returns to be filed by different entities. So there are some that are meant to be filed annually, and there are some that are meant to be filed monthly. So for instance, for an employer, when he is filing, or when the company is filing or paying the deducted taxes of their employees, they also must file a return, a schedule alongside, showing what employees, actually made those payments. Because as an employer, you are an agent to the government for deductions and remittance. And then when it comes to individuals, then you have the annual returns. So when there's a failure, in the issue of filing returns, what the tax authority is left to do is to begin to guess. And that is where the issue of best of judgment assessments comes up, and which is not an ideal situation. As we know, the filing of returns is a constitutional duty as enshrined under Section 24 of the Constitution, So it's a very, very important, and we take it as the very foundation of tax administration. So to that end, we started prosecuting a very, very long time ago. It's been more than 12 years in the making now for failure to file, returns, any form of returns, whether it is a return from the employer, whether it's a return from the individual, or whether it is a return that is meant to be furnished by the banks, because there are different duties and obligations of filing returns. So we do prosecute under the old law, Peter. We have actually it's almost is a criminal matter for failure to file returns. It hasn't changed much under the new laws, the NCAA right now, although there are new penalties that have been introduced. I heard the former speaker talking about the issue of the monthly penalties that accrue. But after a period, these accruals must have a sunset date, because a taxpayer that has failed to file returns and is accruing penalties on a monthly basis, it comes a time when the tax authority will say, okay, this is not just a negligent act. It now borders on, an attempt to evade taxes. And when there is tax evasion, we all know that that is a criminal matter. And then we can now evoke the different statutory provisions as enshrined under the Nigerian Tax Administration Act, to proceed against such a taxpayer. So if I have, I don't know if I'm able to project what I have some slides, bordering on proceedings in revenue matters in Lagos. I don't know if that is possible to project.
You can go and I want to try.
That-
We're working towards that.
Well, maybe what I can do, I can always forward the slide to you, and then maybe to be shared later. Actually, okay.
No, you need to grant it the access. I don't have access.
You can go ahead, Mr. Lange. What later we
Okay.
can.
Yeah.
Get
Okay.
just back.
All right then. Thank you. So I'm just going to, because of our time, I'm going to skip through. We all know the importance of taxation, which is very, very important. You know, tax is considered a first line charge. And this emphasizes the priority that tax matters should receive in legal and financial obligations. Since taxes are considered to be the lifeblood of government revenue, and it directly affects the government's capacity to finance developmental projects and public services and other critical state functions. You know, so it is very, very important that the turnaround time for prosecuting tax cases in the courts is as short as possible, because it has detrimental consequences on revenue generation when there is unnecessary. Yes.
You can now share your screen. Access has been granted.
Oh, okay.
Yes. We are still waiting for you, Mr. Lade.
Yes, I'm trying to do that. You know, maybe I should just
Yes.
maybe I can always just share after I share the you know, so because of our time. All right. Yes. So in Lagos State, it is not always been rosy, and because I'm talking now to my lordships, and you know, so there's a whole lot you know, concerning the judicial front, where we've had issues in Lagos. And it is still also a process. Of course, we have recorded quite a number of successes. However, we are still very, very far from where we should be in Lagos State. Just recently, I think in the last budget, there was a huge amount that the government budgeted, you know, for specialized revenue courts, and then also for the training of revenue judges and magistrates. So we are in the process presently of undergoing those trainings for the judges and magistrates, especially with the new reforms, because if the judiciary and the tax authority, if they are not in sync, then there is no way we can get to the level that is desired, because we know what our society is actually like. nobody wants to pay tax. In fact, all over the world, nobody wants to pay tax unless there is a form of a good deterrence mechanism that is in place to make people to comply. And that is why the work of the judiciary in this aspect is so very, very important. Unlike the Personal Income Tax Act, the new Tax Administration Act, I describe it as a compliance document, is a compliance law. There are so many aspects of this law that deals with that deals with activities that must be taken before the court. And any tax authority that wants to succeed, especially we know that there are a lot of people, especially maybe in Ekiti State now, for instance, may fall under the band of those who are not eligible to really pay taxes anymore. That is the 800,000 naira and below. So what do you now do, to make sure that this gap is bridged so that the people who are earning well, and who are the high income earners and are more of those people that are actually evading taxes are brought into the tax net. So the courts, and that is the judiciary, must be quite knowledgeable. And this knowledge is going to impact when cases are brought before the court, so that whatever, because like I said, there are different areas that we look at in Lagos. If a taxpayer, for instance, fails to submit documents, the tax authority should be able to approach the court to compel the taxpayer to submit documents. Because a lot of the fraudulent activities that we see, where people make false declarations, are from the failure to, provide proper books of accounts. So here in Lagos, what we are now doing, we are approaching the courts. But then when you are approaching the courts and there is slow adjudication of those matters, or there is a kind of like a cognate knowledge gap in that area, then it is going to defeat the purpose. So, and that is why the issue, like I said before, of training is so very, very important in this aspect. So for us, the practical approach of instituting tax matters before the High and the Magistrate Courts in Lagos. For the High Courts, when we have liabilities that are above the pecuniary jurisdiction of the Magistrate Courts, which is presently 10 million naira for in Lagos for the Magistrate Courts, then we approach the High Courts, and we do that through filing of a petition. In Lagos, we have a special order, which is the Order 60, by which we litigate revenue matters. In fact, this particular order, when the 2019 High Court Civil Procedure Rules was in the making, there was a kind of a synergy between the Revenue Authority and the judiciary at that time, to formulate this particular order. So it is by petition, and it is an order where the Deputy Registrar or any other person in charge of the litigation section causes that process to be marked as qualified for fast track. So, and matters are meant to be entertained on a weekly basis. So adjournments are meant to be abridged in that matter when we go through that particular order 60, so that it can bring about quick delivery and a quick resolution of the matter. And then, of course, there are certain other elements, characteristics of that order, which includes areas of payment by installments and other things like that, So I can always, if I don't know what operates in Ekiti State, but we can always make this particular order available, for your own records. So for magistrate courts, we go through the summary summons, which I think is a well-known, originating for originating actions as well. And then, of course, most times when the taxpayer, when we get judgments, is straight to garnishing. That is for, and then of course, for the High Court as well, when we get judgments, on the sum. So I need to examine some of the common obstacles that we do have concerning adjudicating matters before the courts. And these were some of the areas that we brought before the executive, and which forms part of the kind of tinkering that we're having right now with the revenue courts, and then also with the training of the revenue judges. Because if you're going to have a kind of a very expeditious system, we all know that a matter does not just fly onto the table of a judge. It goes through the administrative processes first. So even from the registry, a revenue matter must have a specialized pathway, from the registry, so that the turnaround time, for this matter to get before the court or the judge is well abridged. So we look also at the administrative processes, and then, of course, the judicial processes, because, like I said, the interplay of these two processes determine the efficiency or lack of it in the revenue adjudication process. So in Lagos, we have an online filing system where we go generating reference numbers for each court process, and then the processes are taken to court for initialing, the ACR initials, and stamp all the processes in 1 or 2 days, depending on the number of processes. And then the initial processes are scanned and uploaded in the judiciary site to be assigned suit numbers. This takes about a week after the upload. Then the processes are assigned to courts within 2 weeks of receipt of suit numbers. And then the court registrar gives hearing dates within 1 month after the matter is assigned. So for us, the turnaround time for the administrative processes till a matter comes before a judge is conservatively put at 6 weeks. And for us as a tax authority, that is way too long. Because I don't know what operates in a place like Ekiti State, but in Lagos State, we have, taxpayers who are very, very good at mutating. So you can come to a particular place today and tomorrow you're seeing another name entirely, or in the particular building. They might be doing the same business, but they're telling you that no, that person, the other company, is gone away, and we are still dealing with the same actors, but they've gone to CAC to do some fast whatever, processing and all of that, and they turn things around. So these are the kind of taxpayers that we are dealing with. So when it comes to issue of recovery, we need to be very, very nimble and also able to act very, very fast. So I want to take us back to consideration of some common statutory provisions since we are now in the new regime. I'm just trying to abridge a lot of these stuff, but then, like I said, the comprehensive PowerPoint will be shared with you. So I heard the former speaker going into some details, but for the purpose of this engagement, I think it's very, very important that we look at the power of the tax authority to prosecute as contained in Section 139 of the new Tax Administration Act. This has been very much expanded right now. The tax authority, apart from prosecuting civil matters, has also been given the powers to prosecute criminal matters, of course, with the leave of the Attorney General of the state, as the case may be, and then for the NRS, that will be for the Attorney General of the Federation. So that is well enshrined in Section 139 of the NTAA. Then we have from Section 111 B to 113D of the NTAA, which stipulates offenses for failure to disclose facts in a dutiable instrument. And I think it's very important that we begin to know this, even as a tax authority, that we do not over-concentrate on personal income tax alone. There is a lot going on in the area of dutiable instruments, that is stamping of dutiable instruments. Now this law has made special provisions for the treatment. So it's an offense simpliciter for failure to disclose facts in a dutiable instrument and in frauds in relation to stamps. So these are the kind of cases that I believe that the tax authority should be on the lookout for. You understand? And then be able to push before our courts. Then, of course, we have from Section 114 to 120 of the NTAA, which borders on offenses by authorized and unauthorized individuals or persons, and the inducement of authorized officer. That is very, very important as well. And then, of course, Section 124 to 126 of the same law that borders on false declaration and counterfeiting documents. Like I said before, it's a different thing to file a return. But what did you file in that return? Is it true? Is it honest? So the tax authority must be able to look and be able to profile. So, for example, a person that has got, I mean, I don't want to go too deep into this, but there is a whole lot that is going on. And we, even as lawyers, we might find ourselves, falling into this trap. So if you have, all of us were meant to file returns. When we do file our returns, we may have one or two buildings somewhere where we are generating rental income. Do we declare those? If we have not declared those and we've only declared our employment income, then we have made a false declaration, and that means that the penalties are stipulated, in that section 126 will apply to us, and this is a criminal issue. So we also need to look at these things keenly about what we are doing when we are filing our returns, whether we are making proper or true declarations. Yeah. So also we have from section 127B and 137, that deals with general penalty and obstruction of an authorized officer. Then, of course, our notorious section 61, which borders on distraining, levying distress. Now, this law, unlike what's obtained in section 104 of the Personal Income Tax Act, we don't need to come before the court now to obtain warrants of distrain anymore before the judges. So the chairman of the relevant tax authority can issue a warrant for a taxpayer to be distrained. But when this happens, whatever goods or chattels that are recovered pursuant to that levying of that distress cannot be sold unless we come back, we go to the courts. So that is very, very important. So we still have to approach the courts if we are meant to engage in the sale of any of the distrained goods and chattels. So yes, I think I don't want to go too much into. I've made a case for the need for us to give processing of revenue matters very expedient treatment, because if we're talking about global competitiveness in a globalized economy, companies choose to operate in jurisdictions where the regulatory and legal frameworks are predictable and efficient. And expedient resolution of tax disputes in the high courts, especially strengthens a country's reputation for having a stable and reliable legal system, which can attract foreign investment. I'm happy to say that for the first quarter of this year alone, we have been able to, as an agency in Lagos, we have been able to recover the sum of just over 4 billion naira through the courts. You can imagine, that amount, over 4 billion, and it's still counting. And we're just starting out. So this is the kind of opportunity and what the kind of synergy between the tax authority and the judiciary can bring about. And, apart from even the recovered amount, I may not be able to put a finger to a particular amount that the mere thought what we generate when we send out our pre-action notices, because the taxpayers, they now know that we have an effective judicial system for resolving tax matters. So they know when they get any letter, any notice from the legal department of the LIRS, they are very, very quick to run down to resolve their matters. In fact, tax consultants are fond of telling their clients in Lagos that whatever you do, don't let your matter get to the legal department. And that is, a psychological play that is very, very important, because what we generate from those notices surpasses what we even generate, the actual amount that we generate when we approach the court. And that psychological play is very, very important, to the citizenry. So when they know that the tax authority can not only bark, but can bite, So that is a very, very, like I said, a very, very important aspect, So to round this up, is just to say that in Lagos, we are very, very poised and we're working assiduously to our revenue courts. We are meant to put up a building, but presently we are using the commercial courts with designated revenue judges and magistrates. And then there's work in the pipeline going on, even though we've had some different engagements towards introducing streamlined procedures for filing revenue cases. And then, of course, the continuous training and enhancing non-judicial staff capacity is very important. And I must emphasize this, non-judicial staff capacity, because the recognition of a revenue matter starts from the registry to the court registrars, and then, of course, before it comes before the judges. So this training also must include the non-judicial staff and building their capacity. And then, like I said, continuous training of judicial officers in tax matters cannot be overemphasized. So with these reforms, we believe that, it will reduce all the backlogs, and then, of course, ensure that tax matters are treated within a reasonable time frame. And then, of course, with the expedited manner, tax matters are treated, it will both serve the interests of the government in the collection of revenue, and then, of course, the interests of taxpayers in receiving prompt justice as well, and then generally fostering a healthier economic environment and a more efficient legal system. So thank you very much. I just have to rush through this and abridge some of the issues because of our time. Thank you.
Thank you. Thank you very much. That's the legal, thank you, legal director of Lagos State Internal Revenue Service, Mr. Shigi. Alade, kindly hold on, Mr. Alade. You might have some questions just about 10 minutes. Just to express patience.
Good morning, Mr. Alade. First of all, I must say that we have similar provisions that which is under 55 of the High Court of
Sorry, I'm finding it very difficult to hear. Maybe might have to speak out a little bit more. Sorry.
Can you hear me?
Okay. Yeah.
I've said that it is saying we also have other 55, in order to 55 about high court proceedings related to revenue matters.
Okay.
From what I gather, from what you said, is that proceedings must be completed within 7 days. One day today, and it must run over the. Now, the second issue now is this power of the state and how you go about. My experience anyway is that ordinary such applications are from experts. And if you look at authorities of this issue, particularly the power to levy the state and how to apply, the decision of the FX force, sort of the Court of Appeal, particularly the Revenue and the State Board of Federal Revenue, we are going to say that you cannot bring such application expertly. So my simple question is, how do you do it in the
You can quickly react, Mr. Alade.
Okay, I didn't quite get what he was saying very much. I don't know, but I understand the issue. I heard the parts concerning making the order for district ex parte and the different judicial issues that that have been going on concerning that. I think it's the case has been rested but even right now, the state of the law, if we look at section 61 of the Nigerian Tax Administration Act, it has taken that power totally away from the judicial arm. So now what this section provides for now is where an assessment has become final and conclusive and a demand notice has been served on the person or company, or the person or company in whose name that person is chargeable, and the payment of the tax is not made within the time specified by the demand notice, the relevant tax authority may, in the prescribed form, for the purpose of enforcing payment of the tax due, distrain that person or corporate body by their goods, chattels, bonds, or other securities, or distrain any land, premises, place, or any assets in respect of which that person or corporate body is the owner, and recover the amount of tax due by sale of anything so distrained. So the authority to distrain under this section shall be in the form contained in the third schedule to the Act. And such authority shall be sufficient warrant and authority to levy by distraining the amounts of any tax due. So this says that we don't need to approach the courts for the warrant of distraining itself anymore. Where we need to approach the courts is like subsection 4 of the law that says that where any asset distrained by the service under this section may, at the cost of that person or corporate body, be kept for 14 days. And at the end of that time, if the amount due in respect of the tax cost and charges incidental to the distraint are not paid, they may, subject to subsection 5, be sold only with an order of the High Court, subject to subsection 6. So we must have first levied distraint. So distraint now is an internal issue. And in Lagos, actually, our hotel occupancy and restaurant consumption law, this is the kind of provision that we have. We don't approach the courts when we want to levy distraint on on entities that are covered by that particular law. The chairman of the agency signs the warrant of district and we go out. But if we are going to have to sell, which is rarely the case after all, we've never, in the history of LRS, we've never removed the goods and chattels of any taxpayer, because the intention of the tax authority is not to kill businesses. Rather, we are even in the business of making sure that businesses are thriving, so that we do not kill the goods that lays the golden egg. So we don't remove. So when we even go to distrain is just to shut down and seal the premises, so that the taxpayers can be forced to come forward and settle the tax liability. And even when they come forward, what we still do is we offer payment plan. They pay a certain percentage of what they are owing as a show of goodwill, and then we can give them a payment plan. And if they have still have cogent grounds, we open up for reconciliation for them. So we've never really, we've not distrained, against any goods and chattels and, of any taxpayer by removing it. So I don't know if that's kind of like answer your question, because right now we have left that arena.
I appreciate your case, but if you look at section 61 now section 1A, I have no problem with that, but straight to the question of all. But when you come to this trading land, you understand? It's not being the law of the chairman, so that's nothing. You get what I'm saying?
No, sir.
I think you lie. I think you must get because of the constitutionality of ownership of that is guaranteed. Yes, we put the corporate body goods chattel, but I have no problem. But because of the constitutional guarantee ownership of land, that would be an opinion of remedy.
Sorry, my lord. The position of the law, that regard, there's only groups that are moving with chapter, that ones that we can go ahead to get rid of by warrant. But the position of law is clear enough. If the group is immovable, we can only do that by the other. That's true.
How do you now talk about district, about critical economic infrastructure? For example, I've had within this situation, the formal application for to every district on MTN masts. And I said the question, imagine you're here, you want to work with your child at school, and you're poor. Can you call your wife to work with that work? If you are every district on the MTN master on money. So I just want to know what your view is, because I know you talk about that. When it comes to each time where you have every district of critical natural industry, like MTN.
Sorry, Mr. Moderator, can you repeat? I think I seem to hear you better. Can you repeat what he said? Because there's a lot of echo. I couldn't follow up.
What was trying to, can you hear me?
Yeah.
Yeah, what he was trying to explain is a case of a former chairman, a case of MTN mast to restrict, to destroy MTN mast.
Sorry, sir. So the question the Lord asked which I want to get because I appeared in the court. Yes. It's about a case involving some MTN banks. We were trying to collect some, they were not paying stamp duty, they didn't pay certain NBC, a collection of debt owed to the state. And we went via motion expertise. And Melon said we should put some of those parties, all the parties on notice. So he was asking if you use motion expertise in Lagos or you use motion of notice to bring your matters. Okay, on critical infrastructure, land and mass.
Things like.
Did you get the question now, sir?
Oh, no, okay. So I think he was talking about, do we levy distress on critical infrastructure?
Yes.
Okay. So the way it works for us is maybe because we've not had that kind of experience, and I will tell you why. Because Lagos, we are positioned, maybe I should say luckily positioned or positively positioned, that a lot of the offices, and we're talking about the head offices of some of these companies, are in Lagos. So for instance, if MTN is owing, I'm not going to go to an MTN mass or bring an application to levy distress against MTN mass. No, I'm going to bring an application to levy distress on MTN headquarters, their head office. That is what I'm going to do. So, and I go to their office, I levy distress, even because a lot of times we go to certain places and there's no way you can lock up. So part of levying distress, and like I said earlier, we do not engage in, carrying taxpayers' properties. Even when you look at the storage, where are we going to store those items? So we do not do that. But what we do is, by the levying of that distress, we cause, just momentum, just like a kind of a discomfort. So for instance, if I go to MTN's office now, like now, for instance, let me use a good case. I've had to levy distress on hospitals before, private hospitals. What do? I can't lock up the hospital. I can't drive out patients. So that is like a critical infrastructure as well. So what I just do is I emblazon the frontage of the hospital with my stickers that this place is distrained. So maybe if they have 2 gates, I might say, oh, I lock one and I put my chain there. So that causes I mean, even anybody coming to that place, for any responsible corporate citizen, you don't want that kind of thing to be seen, that, oh, you are owing taxes and they've come to levy distress on you. So we that's what we do for anything that we consider critical infrastructure. But even for us, and that's why this engagement is very, very important, because I had a similar engagement such as this with the FCT revenue judges and magistrates sometimes last year as well, or I think it's almost 2 years ago. Yeah. Where we want to go from, it's not the tax authority going around the road and engaging in all these physical issues with taxpayers. No. And what the new law has done for us is to create different avenues where we can get to the taxpayer without necessarily going physical. So, and that's why I emphasize that we must begin to look at the foundational areas of tax administration, which includes the provision of the issue of provision of documents. When taxpayers don't provide documents, that is an avenue to cheat. That is an avenue to evade. So I want a situation where we are seeing the tax authority bringing applications before the courts to compel a taxpayer to provide proper books of accounts. If that is done, even the taxpayer now, knowing that his matter has already been brought before the court and the court had ordered that proper books of accounts must be rendered, that has softened the ground for the tax authority. And he knows that, oh, if you are now even cooking the books, we can come before your lordships, for prosecuting for false declaration. So because this is eventually what will drive that compliance culture that we need to see in our country. It is not just by going out to lock up shops, to lock up buildings, or we don't. By my own experience, we don't. What we recover from such exercises pales very much in comparison to what we are able to recover from the fear that the agency is going to go before the court to, get certain orders other than warrant of distraint and all of that. So, and that's why I brought this out. It's very important. There are so many areas in this new law that we can approach the court, as a basis to come before the court and engender that compliance in taxpayers. So when you even look at the power of substitution, so if Mr. A has money with Mr. B and Mr. A is indebted to the tax authority, then Mr. B can be compelled to make that payment. And that is what happens when banks are compelled by substitution. Even tenants can be, compelled to hold on to the rent of a landlord and pay it over to the tax authority. And that is what this new law reforms has done for us, which is a very, very, it's a very good shift. You will only need to be in sync to be able to, go through it together, the administrators and then, of course, the judiciary. Thank you.
One more question, Mr. Alade, just one.
Okay.
Yes, thank you so much, Mr. Alade. I was very much this power of the stream given to the chairman LRS. Just do what the stream, I'm still very concerned. The reason being that we are talking of acceleration, which is criminal. Can the chairman not sit in his office on his own discretion, issue warrants on an individual borders on criminal issue? We charge because of cost. So I see no reason why what we take a tax authority to approach the court and get a court order before going ahead just to make it something to get it's better we look at that. It doesn't take anything. Let us have the court, get his court order before the speaking, instead of doing that power to the chairman, because it has to do with criminal matter.
Well, okay. When it comes to there are two aspects to it, my lord. The criminal aspect is not what we apply to courts for to in the case of levying distress. Levying distress is more of is a civil matter. It's just debt recovery. And there are processes, very strenuous processes that must have taken place before a matter can be considered that, oh, okay, this is now the tax liability can be considered as debt owed the state. The former speaker talked about, all the different objections mechanism. And even in this new law, the tax authority must be very careful because if there's an objection and the tax authority does not reply to that objection or do something about that objection after 90 days, there's nothing the tax authority can do. It must uphold the objection of the taxpayer. So before a matter gets to the point of it being considered as a debt, as a tax debt liability, it must have gone through a whole lot of mechanisms. There must have been a notice of assessment. That notice of assessment, maybe the taxpayer has a right within 30 days to object to it. If he does not object to it, the tax authority must issue a demand notice. And that demand notice too, if it is left untreated, that is when the liability can be said to have crystallized. And that is when the tax authority can now begin to chase it as a debt due to the state. But if all the steps and the different statutory provisions that enables the taxpayers in this regard, he has a lot of rights, and even when the matter has become, we say that the tax debt has crystallized, the taxpayer, if he comes forward, that, oh, I want to resolve this, then it's open for resolution. The law even gives effect to that as well. So it's not like when a warrant is issued, because now we have, it's just like a bank. You are owing a bank and the bank gets a recovery agent to go after you. Lawyers are recovery agents for banks. So they can write of course, they can write to the debtor and ask that, hey, if you don't do this, I'm going to do this, I'm going to do this. Of course, you can go to court, file for recovery and all of that. And of course, that is part of what we do as well. Like I said, there are some taxpayers that you cannot even begin to think of you want to go by levying distress on. No. When you look at in Lagos, when you look at the ratio between what we take to court for levying of distress, for an order or warrant for distress, compared to the matters that we actually go for recovery as tax debts, those ones for tax debts are far, far more, because it is better for me to even get a judgment from your lordship and process a garnishee. And that's what we do. When that is done, all the bank accounts of the judgment debtor is frozen. And they cannot do anything. In fact, I recover one of the huge amount that I will recover this quarter is based on garnishee. A 1.6 billion was paid by a particular company when we were able to garnish their account. So if we had gone against this company, because a lot of companies now, They even they have remote workers and all of that. They don't do so much in their offices. So if you go, you lock up the office, they are still able to function. I'm sure if we had gone by this train, we wouldn't have gotten anything close to what we're able to get by doing that, going through that garnishing. So really, for a tax authority, what we do here, when files are sent to us from, we call them our clients, all the units that send files to us in the legal directory, when they send files to us, what we do is actually profile those taxpayers. And the way we profile is we look at their antecedents. Is this one a very recalcitrant taxpayer? Or is this one reasonably a good taxpayer? Or is just this issue that, is thorny? Even then, we do a lot of it, alternative dispute resolution, ADR, here in the legal department. There are lots of matters that we settle. So it is not all about, and that's why I'm saying that we must have a very, very robust pathways of dealing with matters. But if you see that this particular taxpayer is very recalcitrant, those are the only ones we go by, getting an order for district against. Only the very, very recalcitrant ones that only understand the language of force. So thank you very much.
Thank you. Thank you very much. That's the internal revenue. Mr. Laden, please, some patient. The executive chairman has something for you.
Okay.
I want to sincerely thank you for this opportunity. I can remember your face, we were talking about pomegranate or something like that.
Yes. Okay.
Okay,
Yeah.
I want to thank you for all your patience so far. And I'm thinking from the discussions we maybe we will take it beyond there. I know you're going to have a conference soon or whatever. I think two of our lawyers are also going. If it is possible to still meet with Mr. Lade there, we have a few minutes of discussion and then have some other. And if KERS also has to sponsor some of the laws, if you don't mind, to Lagos again and see how some of these things work. It's still for the betterment of it. In my country, from time to time, we send some of our colleagues to Lagos because Lagos has they have more of the evidence that any subnational we want to talk about. So we also consider that, and also the our legal department, they are also to make sure that every one of our basically the law should have a copy of the new law, which you also take a look at. We are also in the process, we have actually detected, but we are trying to reproduce copies of the start law also, which will also be made available to you. And of course, you also have access to us at any point in time, because we just need to work together. Mr. Lade, thank you again for the great opportunity. And I believe when you meet, I wish I could also join the farm conference. Thank you.
Thank you very much. Yes, we look forward to seeing some of our lords, at the CITN conference in Abuja. It's a very, very good avenue also for continuous learning. Thank you very much.
Yes, thank you very much, Mr. Shigalade, for your time and your very educative lecture today. Well, let's move on with the agenda. Now, we might have to tweak the order of events as we continue this program. But before then, let me quickly announce. Yes, if you want to ease yourself, for the men who was the and for the women, straight and that's direction. There are toilets one can use While the two lectures were ongoing, some of our guests, okay, Chief Magistrate AA Omotosho, welcome, Chief Magistrate Omotosho. Yes, it's just trying to welcome. Thank you, Carl. The lectures will come, Chief Magistrate AA, and they also being welcome, sir. And Senior Magistrate C. Are you also joking about the go the director of external contacts. EAIRS is the duty of the that's also but of course the director of building roads evidence and contacts. Thank you very much. And a human resources so safe. So should feel also joking about. Well, it's time for tea break. That's why I mentioned earlier that we might tweak a little. Let's go for a tea break for just about 20 minutes. After which we converge again to continue the other lectures for today. Just about everyone's the back and there will be a 10 minutes.
This time we got late. Oh yeah, I'm machine there.
So when I watch my bank,